folks, before we do anything else, I want to thank council for doing this matter on the virtual platform. As you know, COVID-19 has really affected the way that we can do business. And quite frankly, the bar has been amazing at stepping up, helping the branch move forward and doing the business that we need to get done in order to fulfill our constitutional obligations. So I appreciate that very much. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. The justices will raise their hand. Once you see the hand is raised, whether it's the visual hand or the hand in the program, please stop at that point so I can acknowledge the justice to ask the question that they wish to proceed with. Counsel, are you ready to go forward?
Yes, I am. Thank you. And thank you for accommodating me today as well.
You're welcome.
May it please the court, my name is Pam Nagy, Assistant Public Defender on behalf of Jean Bruny, the defendant appellant. With the court's permission, I would like to reserve 5 minutes for rebuttal.
You have 5 minutes rebuttal, counsel.
Thank you. An ultimate issue is defined as one which cannot reasonably be separated from the essence of the matter to be decided. The ultimate issue in this case was who shot and killed Torrance Dawkins. The trial court in this case improperly allowed 6 witnesses to identify Mr. Bruny at various points on the surveillance videotape, which improperly invaded the province of the jury. What happened in this case is the 3 witnesses, well, in fact, all of the witnesses who were testifying, the lay witnesses, the 5 lay witnesses, and you also have Anthony Imel, who's the state's expert witness. They weren't merely testifying to observed facts. They went beyond their testimony and were making an interpretation. They were giving their interpretation of who is shown on the video. And what happened in this case is the witnesses, Graham and Hopper and Maya, the ones who were there that night at the bar, did not really give anything about, did not describe Mr. Bruny at all. They did not give him any physical characteristics. They did not describe his clothing or his facial features. Really, all they testified was that he was there that night. Graham testified they all entered the bar together as a group. Maya didn't even know where Mr. Bruny was when they entered the bar. And yet they were allowed to point him out at various parts of the video. It's important to note that the video here was not that clear. And of course, this court will view it. But Anthony Imel, the state's expert witness, even testified there were no, certainly, and especially at various points when the shooting was going on, when they're in the bar scene itself, you can't see any facial features. You couldn't see any characteristics, according to Imel. This is his testimony. And for that reason, he couldn't even do his normal analysis, which was to do a one-to-one comparison from a photograph and compare it to the people on the video in order to analyze the video. He couldn't do that here, so he had to enhance the video by enlarging it numerous times and lightening up the colors so that he could do his analysis. Graham also testified several times it's fuzzy. The other witnesses, Jamal Hopper and Maya, they testified, well, it looks like the defendant. And so it was not this crystal clear video. So again, they were giving their interpretation as to who it is at that point. Finan made it clear that there is no exception for identity when the ultimate issue in the case is identification. So even though somebody might be familiar with the defendant, as the people were here in this case, with the exception of Imel, they can't give their opinion that this is the person being shown on the video. And the same was true in Finan, where you had these 4 police officers identifying Mr. Finan from the surveillance videotape. They were all familiar with him. Some of them knew him for as long as 10 to 16 years. But because identification was the ultimate issue, it was improper.
I have a question.
Justice Keller.
Okay. But these people were there. So why can't they look at a video that records what they actually experienced. So this is different from Finan. And they're saying, yeah, there we are. And there's the defendant. He was with us. Something the defendant denied initially to the police. I don't see why that would be any different from their testifying without looking at a video that they were there and that the defendant was there with them that night. That's what they were testifying to. So I'm having a problem comparing this to Finan. I'm not even sure Finan's applicable because these people were there. If someone had taken a still photo and showed them a still photo and said, does that resemble what the scene looked like at the time you were there? I think that would have been perfectly admissible. And I don't see the difference between a video or a photographic depiction of what they actually experienced and their ability to testify that that's what they experienced that night.
Well, a few things. First of all, the only witnesses who were there, besides Nigel Watts, who's the state's witness, were Hopper, Graham, and Maya. His mother was not there, and Anthony.
All right, 4 out of 5. Okay, 4 out of 5.
So, but again, they were not. Yes, they went beyond their personal observations. They were not merely testifying, Mr. Bruny was with me at this exact time, and I remember because he was wearing a red shirt. That's not what they're doing. They're going through and picking out various parts of the videotape and saying, well, yeah, my interpretation here is I think this is Mr. Bruny. And that is what's the problem here. The jury, their task was to look at the video themselves and make an interpretation based on testimony. Certainly, they can testify that they were there and what they saw that night.
You may continue, counsel.
I think there's a question.
My apologies, Justice Khan.
Thank you. I'm sorry, Chief. I think my screen is very small, so it's hard to see my hand, and I'll apologize to counsel in advance. If I put my hand way out there, I apologize. I don't mean to be rude. I guess I'm struggling with your labeling it as an interpretation. Then any time a witness to any event that observes something, in this case, at least as to the 4 individuals, not his foster mom or stepmom, anytime a witness says, yeah, I was there that night, we went together, or I was, at any location, they're doing an interpretation rather than being a fact witness about what happened, what they saw. I think that's where, how does that become an interpretation? They're saying what they saw. They're looking at video of events that they participated in and saying, that's me, that's so-and-so, how is that an interpretation and an opinion versus just simple fact witness? Then anytime the state, or anyone for that matter, in any case, brings someone to relay what happened that happens to be on video, it's going to be an interpretation?
Well, with regard to, they can certainly testify, they were there, here's the facts, here's what happens. But now when they are viewing it on the videotape, they're not necessarily seeing it from their view, what they had that night. They're now going beyond that and saying, well, I think this is so-and-so, which the problem here is part of it's the medium. It's a videotape of the scene. This video captured a 50-minute time period from when they enter the bar, while they're in the bar, and up until the shooting, and then a few seconds after the shooting. And when it's the jury's job to determine what Mr. Bruny looked like, what his physical appearance was on the night in question, while the jury or witnesses can describe it. And, they could even take a picture and say, well, yeah, that's somebody, but not within that same context, but where the jury is being asked to make that decision. They're supposed to be interpreting it for themselves. You're taking it out of the hands of the jury.
Counsel, I think this is along with what Justice Khan is asking. But if I if I'm going to testify that I was in this bar and I was standing and the bartender gave me a vodka and the defendant was standing next to me, and there's a video of that, and I say, yeah, that's me, and that's the defendant standing next to me. Are you saying that that would be inappropriate?
I think under Finan it is. I think they are still making an interpretation as to what they are seeing on the video. It's problematic. I understand that. It's a difficult line to draw. But when the ultimate issue, I mean, that's the key. What is the context that the jury is being asked to, what are they being asked to decide? What is the context that they are being, what is the evidence that they're trying to look at to make that decision? And when they are given this 50-minute video, that's the evidence that they are tasked with interpreting and not witnesses doing it for them.
Well, yeah, I'm struggling with that concept. So let me take a different scenario. There's a bank robbery. I'm the bank teller. The robber comes in, puts a shotgun to my face. I give him the money and he leaves. It sounds like I think you would say that is okay because all I'm talking about the video is that's me. That's the robber coming in. I'm not saying the robber is Mr. Smith. Is that what you're saying, that would be okay? But if I said, no, that's Mr. Smith standing there with a shotgun, that would not be.
Yeah, I think that's part of it because they are now indicating that this is not, they're not saying this is the shooter per se. They're saying this is Mr. Bruny. And the ultimate issue here is as whoever, Mr. Bruny or whoever that is, they're pointing out throughout the video, what does he look like? What does he look like here, here, and here? And it's artificial to say, well, he looks like this here, 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 and here, but not during the 4 seconds when we're not testifying about that part.
Okay, Justice Keller.
What if a person witnessed the whole thing and actually saw the shooting, and then let's say the bank example that Justice Robinson uses, Chief Justice Robinson uses, and then fortuitously there's also a video that the bank video security cameras have made. So the witness gets on the stand and testifies to what he saw, and then they go to the video, and the video corroborates, and the witness says, yes, that's what I saw, and that's the person who shot me, or that's the person who robbed me. To me, if all you have is the witness's recollection of what they saw without a video, you have less evidence than if you have a witness who was there and can testify to what they saw, and then the video corroborates what they saw. All of these witnesses could have testified that he was there, that they entered the bar, that they did this and that. But now we also have a video that corroborates what they said. And think about this not being able to be used in reverse for a defendant. Let's say the person who says, I saw the robbery, gives a story, and then a videotape appears, and the videotape shows a totally different story. Can't somebody say, that's not the shooter is not the defendant, that's the defendant standing over there?
May I respond? I think the problem is that here it's going beyond that, and it's saying it's not just what they saw. They never describe him at all in any detail, but yet they are picking him out on a video without ever giving the jury any facts from which to make that determination. They're doing it for the jury. And I think there are contexts, as Finan said, there are other contexts when a witness can make an identification, but not here when they're naming the person. They're giving their own opinion that it's the defendant. And again, with regard to Imel and his mother, they were not at the scene. So even if you're allowed to have witnesses who were there at the scene, you certainly have a problem now because you have this, first of all, his mother picking him out at just seconds after the shooting, 56 and 59 seconds. Anthony Imel, who was not there at all, certainly gave his opinion that the person who was labeled as MS4 was the shooter. And that is crystal clear the way the video shows the label in red as opposed to every other person who's there in the bar. And when the shooting occurs, the screen splits off 30 seconds before it cuts into two so that you can see both camera angles. And right before the shooting, right at 4 seconds before the shooting, when Randy Hall throws the bottle, the person labeled as MS4 goes behind the victim into this area of the bar. The label comes off as soon as the bottle is thrown, and then the person without a label comes from, again, that same area, shoots Mr. Dawkins, and then runs. And that very next second, you see the person running from the right side of the screen into the left, and then the label reappears, which overlaps. So you can certainly tell at that point it's overlapping part of the defendant's or the person's leg. And so it's crystal clear that Imel has now given an opinion that the shooter is MS4, which other people then connect and say that MS4 is Mr. Bruny.
Justice Kahn.
Counsel, just to follow up on the Chief Justice's questions and Justice Keller's question, what if his mother and Imel, instead of saying, yeah, that's the defendant, say they weren't there, what if they were called by the defense to say, I looked at that video, I know my son, that's not him? Is that an interpretation that should not be allowed?
I think it is making under Finan, yes, I think they're making their own interpretation, and I don't think that it would be allowed. It's still an opinion.
Well, but as to the 4 people that were there, and with the bank teller example, the bank teller may not know the robber personally, but as to 4 of these witnesses, they went together. They knew each other. They knew what they were wearing. It wasn't the circumstance, of a witness who's facing the barrel of a gun and may get nervous and not remember someone's features or what they look like. But these are people that know the defendant. So with regard to the witnesses that not only were present, but were friends or acquaintances and knew the defendant, how does that become interpretation then?
Well, it's an interpretation just like it was in Finan, where the police officers knew Mr. Finan and were allowed to pick him out based on their knowledge. Based on their knowledge of what he looked like, what he walked like, things like that. And so you have that here.
They weren't at the scene. In Finan, the police were not at the scene. Here you have, they know him, they went together, they knew what he was wearing. And I will not ask you any more questions except one, and you can answer when you answer the first question, and that is, how is this harmful to your client when the state introduced an audio tape call of your client saying, I saw the video, it's not great, but it's good enough, damn it. Maybe I can get 15 years. So even if the jury was on the fence about, is that him, is that not him, how is it harmful when he himself identifies himself on the video?
Well, he doesn't identify himself as the shooter, but the way the course of events here went, the entire defense throughout the trial really was that he was not there. I think it became clear at the end at closing, during closing arguments, where they did admit at that point. But the whole case here was, the state went through DNA evidence, they went through cell phone evidence, the tactic that the defense was using up until at the very end was that he was not present at all. So I don't think there's interpretations that you can make as far as this phone call. He could be saying, wow, now it looks bad because I was there. But he's not saying, oh, it looks bad because I'm the shooter. It's not clear at all when you look at the video who that person is. It's very quick. You just see somebody with a white top or light color top and dark pants. That's all you can see. So he's not admitting that he's there or that he's the shooter.
Thank you, Attorney Nege. It'll be Justice Ecker, then Justice Mullins, and then Justice Keller.
Counsel, I know you have a lot of ground to cover and not much time to do it, so I'll be quick. The two issues that were of particular concern to me, I guess I'd say, were the testimony, the opening the door testimony, and the prudent credibility instruction. And I wonder if you could just briefly address harmlessness with respect to those. The question in my mind is harmlessness. If you don't mind addressing that on those 2 points.
With regards to the opening the door, first of all, the defense did not open the door here. Merely questioned Imel as to about this timetable that Agent Loria had given him to determine.
Well, let's assume I agree. I'm sorry to interrupt, but your time
Sure.
is short. Let's assume I agree with you on that. I mean, others may want to hear that. I just am wondering why that was harmful in light of the other testimony that MS4 was the client.
Well, this is the first time that this comes out that MS4 is Mr. Bruny, and it's extremely prejudicial here because, first of all, the whole point of having the label come off during that 4 seconds at the time of the shooting was so that you wouldn't give an opinion as to who the shooter is. And now the court is letting Mr. Imel testify that what Agent Loria actually wrote in his notes was that Mr. Gene Bruny shoots Torrance Dawkins and then exits the bar. If the jury couldn't figure it out beforehand, it's crystal clear at that point. It is harmful. Again, identification was the entire issue. And let's not forget, nobody, not even Nigel Watts, the state's witness, nobody saw the shooting. The case rested on the testimony of Nigel Watts, who had very serious credibility problems. He had a motive to falsify his testimony when he finally comes forward 4 years later. With regard to Leon Pruden, the problem with Pruden is that you also have this, interested witness, who's interested in cooperating with the state, and it's like another piece of the puzzle. It's another piece of damaging evidence that comes in when otherwise the state, again, doesn't have a very strong case.
Can I interrupt you for a sec? Was that the only evidence, other than the visual evidence of the actual moment of the shooting, was that the only evidence that Bruny had a firearm?
Yes, it is.
Okay, thanks. You've answered my questions. I'm done. Thank you.
Justice Mullins.
Okay, I think I'm not muted. Good morning, Attorney Nagy. I don't mean this to be an unfair question, so I'll preface it with that, and I hope that doesn't start off too ominous. But Finan was based on Rule 7-3, and I'm wondering if you had occasion or even thought about what our rule looked like before 7-3, and I'm wondering where that ultimate prohibition on opinion on an ultimate issue, how that comes about, because it seems to me, and maybe you know this, but the feds and most states don't have that sort of categorical bar on lay opinion related to an ultimate issue. You're able to give that lay opinion if it's helpful and would assist the jury. But we sort of laid down this bar, and I don't know exactly where that comes from. And so much of your argument hinges on 7-3 and Finan interpreting 7-3. So I'm just curious if you've had any occasion to see why we came up with that rule sort of as an outlier to how everyone else does it.
Honestly, I don't know. I do not know. I do know the federal rule, obviously, it's explicitly allows it, but I don't know where the rule came from. So unfortunately, I can't really give you an answer.
Could I ask you then, and I appreciate that, and like I said, I don't mean this to be an unfair question, but if we were to think about why we have that rule, why does it make sense? Why does the rule that lay opinion on an ultimate issue should be excluded?
Well, I mean, it's just like with, let's say, sexual assault cases when you're talking more about an expert. You can't give an opinion that you believe this person was sexually assaulted. That is something that the jury has to decide. And if you're allowing other witnesses to come in and make that determination for them, when that's really all they have to decide, well, how is that fair? How is that a fair trial? It's certainly not fair. And that's why we have the rules with regard to, sexual assault cases and things like that. Drug cases. People can't go in and say, well, yeah, that was possession and that person intended to sell. The jury has to make that. That's why we have jury trials. It's unfortunate.
But they're not. This wouldn't be. That's the person necessarily. That's the person that committed the crime. It's just identifying the person from a still or from the video. Why wouldn't that be admissible, but everything else go to the weight?
In this case, you have to look at the entire context and the totality of the circumstances. The way this comes in through multiple witnesses, as well as, the people who were not there, making it crystal clear that it is Mr. Bruny. I mean, you can't come to any other conclusion that it's Mr. Bruny who's the shooter. I see my time is up.
Counsel, I believe Justice Keller had a question.
Just quickly, the charge of criminal possession of a firearm was only based on the incident of the shooting and not on the day when the witness saw someone he knew as Gunner holding a pistol in his hand?
I don't believe it was. They never connected the two guns. So from my view, it was based solely on what's on the video.
Didn't Watts testify that the gun he saw when the shooter fell down after the shooting was a little bigger than his hand?
I don't recall that testimony. I could be mistaken, but I don't recall.
If he said that, wouldn't that be sufficient to identify it as something that's less than 12 inches?
I mean, I guess you can make that inference, yes.
All right, thank you.
Mm-hmm.
Thank you very much, Counsel. You have your 5 minutes.
Thank you.
Attorney Weiner.
May it please the court, my name is Matthew Weiner. I'm an assistant state's attorney with the Office of the Chief State's Attorney, and I represent the state in this appeal. I'll start with the defendant's first issue, the fine-in issue, and I actually want to just start with a bit of housekeeping. The defendant challenges in his brief with respect to the fine-in issue the testimony of Graham, Hopper, Maya, Simons, and Imel. So those are the witnesses that are before this court. In the errata sheet he filed the other day, he did make reference to Watts. That is clearly not an issue on appeal. It's not a fine-in issue on appeal, nor was it, although the errata sheet makes reference to an objection. The objection wasn't on the basis of fine-in at the time that came in. It was on the basis of whether the exhibit from which Watts was identifying MS4 was a full exhibit or not. When it was, when defense counsel was corrected and the trial court said, well, that was a full exhibit, defense counsel said, okay. So just a clarification, the Watts has nothing to do with the fine-in issue in this case. But with respect to the substance of the fine-in issue, to be clear, for there to be a fine-in problem, the defendant must establish both that the challenged evidence constituted opinion testimony and that it embraced an ultimate issue. Because here the defendant established neither, the trial court reasonably admitted the evidence. With respect to the defendant's argument today, the defendant's argument today is focused on the opinion versus fact distinction. And admittedly, that can be a difficult line to draw. But what is crystal clear in this case is that the evidence, the identification evidence offered by the state here did not go to the ultimate issue. Specifically, Tyrone Graham, LaToya Maya, and Stephanie Simons identified the defendant as the person who entered the club 50 minutes before the shooting. That obviously was not the ultimate issue because the fact that the defendant entered the club 50 minutes before the shooting did not establish that he was a shooter, especially where DNA evidence established and the defendant conceded before the jury that he was present at the club on the night of the shooting. In addition, Hopper, like Tyrone, identified the defendant as the person who entered the club with Tyrone Graham and as one of many people near the club 30 minutes before the shooting. Again, 30 minutes before the shooting did not establish that the defendant was the shooter. Same thing with the defendant's foster mother, Simons. She testified that one of the people fleeing the club looked like Gene. This was seconds after the shooting. That too didn't prove that the defendant was the shooter because there were dozens, if not hundreds, of innocent people fleeing the club at that time. In fact, defense counsel in her closing argument seemed to suggest that this identification was actually exculpatory because what shooter is going to flee through an entrance that has an obvious video camera on top of it? So again, even if the jury credited the identification made by Simons, it did not establish on its own the defendant's guilt. With respect to Imel, again, Imel's in the same position because he did not identify the defendant as the shooter or even as a person on the enhanced video. He specifically testified that he could not make an identification of the defendant or anybody else, even though he was asked to do so. And so again, the fact that MS4 was the shooter, at least under Imel's analysis, did not establish that the defendant was the shooter, which again was the ultimate issue.
Justice Daria, then Justice Keller.
Thank you. Counsel, what this may go to both to this issue you're talking about, the fining issue, and also the opening the door issue. What exhibit is it that tells us what Loria gave to Imel? Is it a raw video in some fashion?
Well, in terms of, yes, I think the testimony was that Loria gave Imel essentially Exhibit 7 and Exhibit 8 here. So that Exhibit 7 and Exhibit 8 are the raw video. There was also on Imel's cross evidence presented by the defendant that indicated that Imel was also provided certain notes or certain stills.
Oh, okay. So that is it. The stills in the note, because many of us have watched the enhanced video, but I've not at least seen what was given to Imel. Are you saying it's the notes and the stills that where the notation is put? You know, Gene Bruny here, Gene Bruny here, Gene Bruny here.
Well, no. In fact, so the stills, nothing that Imel produced ever had Gene Bruny's name on it. So not
that he produced, that he was given. Loria gave him.
Those were notes. Those were Special Agent Loria's notes that used the defendant's name.
Used his name, and at 7:56, at 7:58, at 7:59.
Correct, Your Honor.
What are they giving him that for? What I thought that was his job to track who was who, where, and when. Why would they give him stills or some sort of a video that says Bruny here, Bruny here, Bruny here?
Well, this again. So the stills is a separate. The stills is a separate issue. The stills were basically Loria saying, "This is who I would like you to follow." This is.
But with his, not just. I mean, it's not that the name was given, but that in Loria's view, he's here, he's here, he's here. I thought that was the whole expert that was his job, was to say he's here, he's here, he's here. He's calling him MS4, but I mean, isn't that very suggestive? You know, this is what I found. Can you tell me what you find?
Well, I think the testimony absolutely was that that the expert here definitely was provided Loria's opinion, but the expert also testified that he provided, although at the end of the day their opinions were consistent, he conducted his own evaluation that took him 4 months, hundreds of hours.
Understood. But I mean, at least we'll confine it to the fining issue at this point. It comes very close to the ultimate issue if what's going in is Bruny's notes. I'm sorry. The agent's notes, Loria's notes saying Bruny, and Imel tracking the same guy, but with a 10-second gap where the shooting takes place.
Well, to be clear, Your Honor, Loria's notes came in pursuant to the defendant. The state didn't elicit that testimony. So the state, it was the defendant who was questioning Imel using Loria's notes and who was misrepresenting the content of the notes, so that on redirect, it was only then that the state came around to say, well, we need to correct the record here as to what the notes said.
Okay, they correct the record by saying, you know, using actually his name as opposed to MS4.
Well, correct the record to show that Imel had not adopted Loria's, well, the defendant's obvious suggestion was that all Imel was doing was adopting what Loria had told him. But in fact, there was a distinction, an important distinction. And that was.
Let me, I want to give my colleagues a chance, but let me just make sure I understand. And you tell me if I'm oversimplifying this, I'm sure you will, or if I'm misrepresenting this, I'm sure you will. Imel testified that it took him 3 months or more to track these guys, everybody, but including M4, you know, at this time, at this time, at this time. The defendant then says, well, you did this detailed, nuanced, painstaking inquiry, right? But it's true that Loria, when he transmitted to you his information, he said, Bruny is here, he's here, he's here, or suggested it. And the ruling that it opened the door was to say, well, can you repeat what Loria told you that didn't have an influence on you? Am I right? That's how it comes in?
No, I disagree, Your Honor. I think the sequence was correct up until the point where what the defendant, the cross-examination, what the defense attorney was saying was, and Loria told you, so Mr. Imel, you concluded that this is MS4 in all these spots. Special Agent Loria told you that this is MS4 in all of these spots. That was not accurate, Your Honor. That it was the note. So the suggestion was that all Imel was doing was adopting that opinion. So it came in, and actually it didn't even come in as part of an open the door. The primary reason it came in was as non-hearsay evidence, because what the state then elicited was, well, wait a second. It wasn't that Loria told you that it was MS4, therefore there's not a connection, a direct link between your conclusion. In fact, Loria told you something else, right? And in fact, you, Mr. Imel, have already testified that you did not reach that conclusion, correct? And so what the state is doing is, again, showing that there is daylight between what Imel
did not reach what conclusion? That it was Bruny using the name.
Bruny, correct.
But but it's the same guy. It's whether you call him MS4 or X or Bruny, you're tracking him. And that's what I take, without using the name, that's all I took the defense counsel to be suggesting. And the idea that opened the door to Loria then saying, to bringing in Loria's identification of the defendant by name seems to me to be a stretch.
Well, again, Your Honor, I would just point out that wasn't the objection below. The objection below was that this was hearsay. Judge Blue then very clearly articulated that this is not hearsay. I am not permitting it to come in, for the truth of the matter. It's coming in for the same reason, defense counsel, that you elicited the testimony regarding the notes, which is to show the effect or the lack of effect on the expert here. So that was the evidentiary ruling. That was the basis of the objection, as well as the evidentiary ruling by Judge Blue here.
Attorney Weiner, I believe Justice Ecker has a question.
Yeah, I must tell you, Mr. Weiner, with all due respect, I find that argument to be disingenuous. I mean, the idea that this came in, the evidence was Gene Bruny shoots Torrance Dawkins and exit towards hallway, right? That evidence, the opinion of Loria, that this is on that ultimate critical issue, which is kept away from the jury. They go so far as to use code names, MS4. There's a claim, he opened the door. So now it strikes me as a deliberate gotcha. And it was extremely effective, and the trial judge let it happen. There wasn't questioning about that particular time at 7:56. The defense lawyer had certainly was trying to establish that this witness was testifying under some direction of the agent. right? Fair game. But to use that as an excuse to then say, well, it didn't affect you, did it? That it didn't affect you. It had no effect on you. That Bruny, that the agent believed that Bruny shoots Torrance Dawkins and exits toward hallway. That had no effect on you, did it? Are you really saying that's fair game?
What I'm saying, Your Honor, is that the defendant's objection to that testimony was that it was hearsay. And the trial court correctly concluded that because it was not being admitted for the truth of the matter, it was not hearsay, just like it wasn't hearsay when the defense counsel was asking attorney.
So you're saying that they made the wrong objection? I mean, the judge specifically referred to opening the door.
Well, he certainly said, correct, that counsel opened the door after the trial judge ruled that this was not hearsay and it was going to be admitted. There was further discussion, and in that context of that discussion, the trial judge said, yes, and counsel, this is you open the door to this type of evidence by going down it, not improperly, but you're the one who introduced the subject. Even
though there was no questioning about the notes at this particular time period, would you agree with me that this is devastating evidence?
I disagree with you, Your Honor.
Okay.
Because I don't. May I?
Well, tell me why. I mean, there were a lot of efforts to keep it out of evidence, right? I mean, the whole idea of using these labels was not to get into who each person was, and now we have disclosed to the jury that the investigating agent believed that this is the moment of the shooting and this is the identity of the shooter. Tell me why that's not devastating.
Because I don't think that a jury would be surprised or their emotions would be aroused to learn that the lead investigating officer in a case that results in a murder charge against the defendant believed that the defendant had committed that murder.
Well, just one other question I'll ask you. Would it have been inadmissible? I mean, if it had been offered by the state, would that have been inadmissible? Putting Laurie on the stand and asking him who was this who did the shooting? Would that have been inadmissible?
Well, so asking Laurie who he believed was the shooter based on his investigation.
Yes.
I think that if the trial court sustained that objection, it would not be an abuse of discretion to rule in that way.
Well, what about if he had not sustained the objection? Would that have been abusive discussion?
Well, I guess again, I think it's difficult to answer in a vacuum because.
Okay, well, I don't want to push you on it. If you don't want to concede it, I'm not going to push you any further. I'll give the floor to others. Yield the floor, as they say.
Thank you, Justice Keller, then Justice Kahn.
Counsel, can you answer my previous question? The charge of criminal possession of a firearm, was it based only on the possession of the firearm the night of the incident, or was it also based on what Pruitt saw at somebody's house where a gun was in the hand of someone named Gunner?
So I don't believe that it was specified. However, I do think certainly the state's argument was that the gun that is evident on the video, which can fit in the person's hand, of course, and a hand is, any individual person can see that their hand is 4 or 5 inches, whatever, obviously could not have a barrel of a foot or more in length. Oh, so I think it's the video itself that is conclusive proof that the defendant possessed that firearm.
I have one more question. Do you think that the fact that Nigel Watts became familiar with the defendant at the memorial service and also saw the defendant, and that was prior to being sent any text with a picture of the defendant in it, and also how is that suggestive at all that Nigel Watts had previously seen the defendant at a memorial service?
It's not, Your Honor. In fact, it approaches an independent basis of his knowledge for his identification of the defendant. So it makes it makes the admissibility of that testimony stronger, not weaker.
And how was the encountering him in the lockup not suggestive?
Well, it wasn't suggestive, Your Honor, because in those cases where courts have found that to be suggestive, there is some connection between why the person is in lockup or in court or incarcerated and the charge. Here, there was no evidence that years after the shooting, when they both end up in court on the same day, that Mr. Watts knew that the shooter, the Cheetah Club shooter, was going to be in court that day and therefore had a connection between who he saw in lockup and the charges. So that's the reason why all of the cases that the defendant relies on are distinguishable, and it was not suggested in this particular case.
All right, thank you.
Counsel, I have two questions. I'm going to tell you what they are, and if you can answer them in whatever order you prefer. So my first question relates to the issue of Gloria's opinion that the defendant was MS4 and the shooter that comes in through the argument of opening the door. Assuming this court were to find that that went too far, but also assuming the court were to find that the testimony of the other witnesses about what they saw that night and identification on the video came in your view, what can you tell us that would establish that letting that in, even through the open door argument, was harmless to the defendant? So that's my first question, the harmless aspect of that coming in. And the second question is, you're advocating for this court to overturn Holloman. And I understand your argument that here, the suggestiveness did not involve state activity. But even in light of recent jurisprudence on eyewitness identification, I could envision a situation where the state could be involved indirectly in directing private conduct. So why should we overturn Holloman when there could be potential factual scenarios where Holloman might apply? Those are my two questions. Thank you.
Sure. So I'm going to go in order of your question. So the harmlessness of the Lauria's opinion, I guess what I'd rest on is the harmless error that's in the brief that focuses on the video. Assuming the video came in properly and all the identifications came in properly, what we have is we have a group of 5 men, and at that point, there is no dispute that the defendant is in that party, right? They all come in together. The cell phone evidence establishes that they all leave together. And the video depicts all of them together in that corner of the club, which is consistent with all of the other testimony. What we then have, fortuitously for the state, is the fact that all 5 men are readily distinguishable in their characteristics. Certainly, we don't have any close-ups of their faces, but what we have is we have Solomon Graham and Tion Simmons, who are very tall and athletic. The testimony is that Tion is 6'2", Solomon is about 6 feet, 6'1", and so we have them. And fortunately for the state, Tion is wearing a huge gold chain, and so we can distinguish the two of them. We then have Randy Hall, who is extremely small. He is by far the smallest person. That is the testimony of the witnesses, and that's what's reflected on the video, and he's the one who threw the bottle anyway. So we now counted for 3 people. Tyrone Graham is about middle-sized, but he's a very large man. And in fact, the video shows that he goes to the bathroom at the time of the shooting, so he's not even in the room. So now we've counted the 4 of the 5 individuals. And then lastly, we have the defendant, who is about average size, about the same size as Tyrone Graham, but he is rail thin. So just by virtue of that fact, that we have those characteristics of each of the 5 members of this party, and we can see on the video what appears to be a very choreographed effort to carry out this murder by the various parties in terms of where they go, and in terms of Solomon Graham removing one other person from the vicinity, and again, Tyrone Graham leaving. So that's even setting aside Watts's testimony and some of the other evidence as well. So again, I would just keep bringing the court back to the video for the harmlessness of any of the other evidentiary rulings. With respect to the Holloman claim, Your Honors, respectfully, the state suggests there are 4 reasons why this court, notwithstanding any possible hypothetical situations where, like as Justice Kahn noted, there might be some gray areas down the road, there are nevertheless 4 reasons to reverse course. Number 1, and I think this addresses Your Honor's concern, is that it's not like if Holloman is overruled, this evidence will automatically come in. In all of the jurisdictions that are cited in the state's brief and in the defendant's brief, the claims are evaluated through basically an endless number of factors. They include your typical prejudice versus probative value. It includes looking to factors such as the federal factors. And it also includes looking to factors such as, well, is there a trial court instruction that's given? Is there a proposed defense witness? So from the state's perspective, it's just a matter of giving the trial court all of the tools possible and necessary to make the best possible decision. In fact, in Connecticut, there's actually an anomalous situation where under Holloman, it's the federal due process standard that controls. Yet in State versus Harris, this court ruled that under the state constitution, those 4 factors are not good enough. So what the state is arguing is that the trial court shouldn't be cabined to those 4 factors that this court has already held are insufficient. And it should be a general finding that can rely both on the federal factors, perhaps even on the state factors, and also taking into account any jury instructions, any future developments in eyewitness identification law, any proposed expert witnesses, or what have you. So from the state's perspective, it's a logical change. In addition, as I already mentioned Harris, but in Harris, well, I should say in Johnson, this court, like the U.S. Supreme Court, recognized that a heightened due process standard, when private conduct is involved, that there's a tension there, because the point of the heightened due process standard is to essentially make sure that when the state is involved in bad conduct or negligent conduct or just improper conduct, it's the state that pays that penalty. But when the state isn't involved, when instead it's a private actor, it's the more broader question of, well, is that testimony or is that evidence more unduly prejudicial than probative? So again, there is a check, but that heightened standard just doesn't logically apply when the state's not involved. And again, I guess just the other couple of points is that, as I think I already mentioned, the state's position is consistent with what basically every jurisdiction, Wisconsin, New Jersey, that are cited in the briefs. And then finally, reversing Holloman and going under the general 4-3 Code of Evidence standard would also clear up some of the confusion that's evident in this case regarding, for example, the standard of review or the harmless error standard. The state's perspective is that after Holloman and after Johnson, it is clear that this is an evidentiary call and all of the evidentiary calls apply, all the evidentiary rules apply. The defendant disagrees and says that although it's an evidentiary ruling, there should and it has some due process connotations, there should be scrupulous review or some other appellate standard than the typical evidentiary standard. So again, it's just a matter of bringing the law all into conformance with one another.
Justice Keller.
This claim that this identification of Watts was so egregiously unreliable shouldn't apply when it's not state involvement, not state action, correct?
Yes, that's how I understand the defendant's claim to be, yes. And again, from the state's perspective, as the trial court explained, this was an absolutely reliable identification because this wasn't a circumstance where you have an identification made for the first time at the moment of the criminal activity. This is somebody that Watts testified he had seen him a month earlier. He had a close-up view. He's at his car for about 30 seconds. He sees his face. He knows this person. Fast forward a month, he recognizes the defendant immediately. So as he comes into the room, he recognizes him not, of course, by name, but he recognizes him as the individual who he saw previously on Wood Street. And then he sees the defendant go around back. And just, I guess, one other point I'd like to make is the defendant tries to make much of the fact that although Watts was certain that the defendant was the shooter, he didn't actually see the shooting. And that is true. Watts was very clear. He didn't see the shooter, but what he saw was the defendant go behind him. He saw the fact that the defendant was the only person behind him, and then he saw the defendant with the gun right after he heard the firecracker sound on the floor, feet, if not inches, in front of Watts and the victim.
Justice Ecker? You're muted, Justice Ecker.
Thank you. On the prudent credibility instruction, real quick, the just first factually, did he first come forward when he was incarcerated, or did he come forward? Is that right?
That's my understanding. Yes. Yeah.
Assuming, I mean, I know it's hotly contested by the state, but assuming that we were to disagree that the credibility instruction being given, and find that it should have been given with respect to him. Can you argue harmlessness from the state's perspective on that? With particular reference, I had asked Attorney Nagy on the other evidence about the gun.
Sure, Your Honor. And again, with respect to the gun charge, as I indicated earlier in response to Justice Keller, the best evidence of the gun charge is the video that shows a handgun about the size of a hand in somebody else's hand, right, in the defendant's hand. And so if that gun itself is less than 12 inches, of course the barrel is less than 12 inches. And so on the gun charge, that's a harmless error. With respect to the rest, sure. Again, I hate to keep giving the same answer, but I bring it back to the video. Was it helpful to the state that Pruden said that a month before he saw the defendant with a gun? Sure. But it paled in comparison to the video evidence in this case and the testimony of the eyewitnesses who placed the defendant, and I'll add on the DNA evidence that places the defendant in the room where the victim is shot on that evening. I see that I have 1 minute remaining, but if there are no further questions from the court, the state respectfully requests that this court affirm the trial court's judgment below. Thank you
very much, Attorney Weiner. Appreciate it. Attorney Nagy?
Yes, thank you. With regard to this reliability of the ID from Nigel Watts, it's funny that this memorial service identification, this issue comes up. He saw him a month before the shooting, and as the state's attorney says, he immediately recognized him. Well, that's not true. He told the grand jury a year later, in November of 2014, he didn't know anyone with Hove. The only person he recognized was Hove, Randy Hall. That's it. And he only tells the police about this 4 years later, in July of 2017, after he's seen Mr. Bruny in the lockup, in the bullpen right next to him. So for the state to say that he immediately recognized him and this is a reliable identification is, I think, a very big stretch here. Hove, as far as his reliability, he tells the police at night he didn't even see the shooting. He didn't even know his cousin, who was standing right next to him, had been shot. He later describes before the grand jury the shooter wearing a red collared shirt and a black hat with a brim pulled down low over his forehead. Well, we know that's not true. He maintained throughout 4 years until right before trial that the shooter was wearing a hat. I believe there's a question.
Justice Kahn.
Yes, thank you, counsel. My question, I understand the point you're making here, but as far as him coming, according to the state, coming clean, I suppose that's how the state would label it. But according to him coming forward 4 years later, after he sees your client in the lockup and he says he tried to hide his face, is that uncommon in investigations of this type, that someone would not come forward immediately, would deny having any knowledge or identifying anyone, and then later when they get their own charges against them, all of a sudden they'll come forward? Is that an uncommon occurrence?
Oh, certainly not, because now he has an incentive 4 years later when he's charged and facing 43 years. And the incentive doesn't mean he's coming clean. The incentive could be that he's falsifying his identification so that to curry favor with the state. And
doesn't that go to weight then? didn't the defense precisely argue that? And as far as Watts, actually get an instruction, a special credibility instruction to make precisely that assessment, whether he's really coming clean or he's motivated by something else 4 years later.
Certainly the defense counsel made that, but my point is here, and I want to make it clear, he didn't suddenly recognize Mr. Bruny and just only in July. It's the first time he mentions this memorial hearing, but he approached the police in the state in January of 2017. Right, you know, now that he's been charged, he reaches out to them. He wants to cooperate. So you have to take that into account. It's not that he's suddenly coming clean because he recognized Mr. Bruny. That's not how the events played out here. He had ample reasons to try to bring Mr. Bruny into this, but this, again, think about this as his favorite cousin. You know, yes, this is pretty common, but it doesn't make sense when he repeatedly misidentifies what the shooter describes, what the shooter looks like, what he's wearing. He claims he's never seen the shooting. You have all of these factors here. He tells, you know, that he tells the grand jury he didn't know anybody with Hove that night, and yet 4 years later he knows him. And I would like to say, as far as the Nigel Watts and the errata letter that I wrote, I was pointing that out in an abundance of caution because I wanted to bring it to the attention that, not that it's part of the Finan issue, but it came out and I had overlooked that he had identified Mr. Bruny as being MS4 from this still of the enhanced videotape. And I wanted to make it clear that there was another identification. And if anything, it goes to the harm here because now he's connected Mr. Bruny with MS4. So I just wanted to make that clear. As far as overruling Holloman, I think Justice Sotomayor in Perry versus New Hampshire gives a very good dissent, which really encapsulates what our position is. And the focus should be on reliability. Even though there may not be any police action with regard to the suggestiveness. Thank you.
Justice Doria has a question.
Quick question. I'm sorry if you've made this clear. Is Finan to you an issue about videotape? Opinion off of a videotape?
I do think that it, under the facts of Finan, yes, they were talking about the videotape. Now, then does it become a still photo from the videotape?
Well, I guess my point is you wouldn't call, if, let's say the video camera is attached to a building, but the percipient witness was right there where the video camera was. We wouldn't call, if the percipient witness says at trial, I saw John Smith shoot the victim, no one would call that opinion, or at least not an admissible opinion, right?
If he's actually saying, no, I don't think that's inadmissible.
Right. So the difference is what? That it's on videotape and that the jury can see it? Because the jury doesn't have any way of measuring whether he's accurate or not when he says, you know, I mean, it's always his opinion, I guess you could put it that way. It's always his opinion that it was John Smith. And you can cross-examine him for familiarity or, you know, how he could see, you know, how well he could see him or anything. But you think the difference is the fact that it's on a videotape? I
think the problem is it's in Finan, if you agree that it's the person on the videotape, then it has to be he's guilty of robbery. And that's what you have here, because on the videotape, if you agree that this is Mr. Bruny on the videotape, then the fact that these other witnesses are repeatedly identifying him, with the exception of this 4 seconds, it is tantamount to giving an opinion that, yes, he's the person on the videotape, he's guilty of the shooting.
But that's the ultimate issue. Identification is the ultimate issue for the recipient witness, too. He says that if the jury believes that, that's the whole case. So, go ahead.
Well, you know, I think the distinction in Finan is that it is on videotape, and how far that goes, you know, it's unclear. But that's my read of Finan, and that's what you have in this case. And if it wasn't with regard to Graham and Maya and Hopper, you certainly still have the problem with Imel and his mother.
Thank you.
Thank you.
You're mute, Chief.
Apologies. Thank you very much. Sorry about that. I want to thank council once again. We shifted to this virtual platform at the last moment. Had some technical difficulties, but I really appreciate council being patient and for working with the branch to make sure that we fulfill our constitutional duties. With that, we are going to adjourn until tomorrow morning. Thank you very much. I will see my fellow justices in